Hello students, I'm Swati Parmar. I'm an assistant professor at Dharmashastra National Law University, Jabalpur, Madhya Pradesh. Today in our lecture, we will discuss about state recognition. State recognition is an important topic in international law for the purposes of legal reasoning section in CLAT UD exam. Besides it always is a significant topic for current affairs section as well, because uh, as and when new states are formed, the question of whether how to recognize this state as a state becomes pertinent. So that makes state recognition as one of the very significant topics of international law. So in our today's discussion, we will focus on few aspects of state recognition. We'll begin with the meaning and prerequisites of state recognition. Then we'll look at the theories of state recognition, followed by kinds of state recognition. And then we will look at a few handful case studies for you to understand how state recognition pans out in practical relevance. And then we will discuss what are the ramifications of non-recognition and what is the meaning of non-recognition. So let us begin. Let us start with the meaning of recognition. So what is state recognition? State recognition, as the name suggests, is recognition of a state as a state in the eyes of international society. That means that whenever a state is formed, a state may be formed as a new state, a state may be formed by division of an existing state. A state may be a new-found state, for example, a new-found island, or an island which is formed by volcanic eruption, etc. So whenever by these and other such means, whenever a new state is formed, there is a question that whether this state is to be recognized as an autonomous, independent, free state. And the act of recognizing a state as a state is at the discretion of other states. So, for example, there is a new state, say state X. Now, it is the discretion of existing states A, B, C, D, to recognize this X as a state or not recognize this as a state. So, state recognition is at the discretion of recognizing state. Recognizing state is the state which is giving recognition to the newly formed state as a state. So this discretion is followed by the political will of the state. So recognition is not per se a legal act, but it is a politico-legal act. That means that it's not purely a legal in the legal domain, meaning thereby that the recognizing states or the existing states of the world are not under a legal obligation to recognize a new state as a state, but as per their friendly relations, as per their diplomatic tendencies, as per the international politics prevalent, as per other beyond law, beyond legal factors, the states decide whether to decide a new state as a state or not. So therefore, recognition is known as not a purely legal aspect, but a politico-legal aspect of state formulation, right? Now, that takes us to another question, that how do you decide that a state is to be recognized as a state? So there are few prerequisites or conditions which, if a political unit fulfills, then such state may be considered for being conferred state recognition, for being recognized as a state. That means that I use the word political unit because states are known as the building blocks of international society or political units of international society. So any political unit, a piece of land which has boundaries, borders, it is a political unit in that sense. So if any political unit fulfills certain conditions, and these conditions are conditions of statehood, only then the state attains statehood. Only then the state can be recognized as a state by the existing members of the world community, by the existing states. Now, what are these prerequisites and where do they come from? So these prerequisites are mentioned in a very important document, which is a convention, and it is called Montevideo Convention on the Rights and Duties of the State. So this is a convention which deals with various kinds of rights and duties that the states of the world have. And this convention begins with prerequisites of statehood under the very first article. So Article 1 of Montevideo Convention on the Rights and Duties of States, which came into force in 1933. This mentions 4 prerequisites for statehood. Right? Now, the 4 prerequisites are the 4 requisites that are mentioned in the convention are a definite territory. So a territory which is definite, that means that moving boundaries are not there. There is a clear-cut, marked, known boundary of the state. So a definite territory, not indefinite territory. Second is permanent population. So permanent population has to be there of that political unit. That means a state with nomadic population or moving population will not fulfill the prerequisite under Article 1 of Montevideo Convention. Then a stable government, a government which has significant level of stability. And then the power to enter into contract. So the power of a state to enter into contractual obligations with other states. So these 4 criteria defined territory, a permanent population, an independent, stable government, and the ability to enter into contracts with other state. These are the 4 conditions of statehood as mentioned under Article 1 of Montevideo Convention. Now, Montevideo Convention mentions about these 4 prerequisites, but that does not mean that these are the only 4 prerequisites that will classify any political unit as a state. There are scholars who have talked about additional prerequisites also for the attainment of statehood, right? But then again, let us remind ourselves that if a political unit has these prerequisites, it fulfills all the 4 prerequisites, that does not mean that it has a legal claim of it being recognized as state against other recognizing states. What does this mean? This means that the existing states of the world cannot be forced by the new political unit that now I have fulfilled these 4 conditions, now you are under a legal obligation to recognize me as a state. Right? Now, this may sound a little confusing, but we'll clarify on this point later when we discuss about theories. So let us move to theories now. So state recognition is described, the procedure, and what are the ramifications of state recognition. This is described by 2 sets of theories. One is constitutive theory and another is declaratory theory. But before moving to theory, let us first see one very important provision of the same Montevideo Convention 1933. It is Article 3 of the Convention. Article 3 of Montevideo Convention on the Rights and Duties of States, 1933, says that the political existence of the state is independent of recognition by the other states. And this clarifies the point that I was making, the last point that I was making on prerequisites of statehood. This says, Article 3 says that the political existence of state is, of course, there, and it is not dependent upon the recognition by other states. So whether or not other states of the world recognize a new state as a state, that new state definitely has become a state, right? So a state, once it has, broadly speaking, once it has the 4 prerequisites mentioned under Article 1 of the Convention, so that has a defined territory, it has a permanent population, it has a stable government, it has the ability to enter into contract. So once these broad 4 conditions are there, are met, then a state becomes a state. Now, whether or not other states recognize it as a state or not, that is a political question. But that state has definitely come into force. So state X, if fulfills the 4 conditions that we discussed, then state X has become a new state. State A, B, C, D may recognize it later on. But if state A, B, C, D have not recognized state X as a state, that does not cease the political existence of state X. That means state X is still there. So, for example, suppose your parents tell you, imagine a situation where your parents tell you that we will give you a cell phone, a mobile phone, only when you attain the age of 16. Now, you, on your 16th birthday, you expect that you want a cell phone. Your parents joke and they say, in a comic sense, they say that, okay, it's your 16th birthday, but you are yet not 16. You behave like a 10-year-old kid. You actually are not mature enough to have a phone. What does that mean? That means that the parents do not recognize you as a 16-year-old for the purposes of giving a mobile phone. But factually speaking, you have attained the age of 16 years, right? So similarly, a state has come into existence, a state has been formed, and political existence of state is there, regardless of the fact whether it is recognized so by other states or not. So Article 3 of Montevideo Convention is a significant understanding on state recognition. Now let us move to 2 theories that describe state recognition. One is constitutive theory and another is declaratory theory. Constitutive theory, as the name suggests, says that a state is constituted only when it is recognized so by other states. That means that state recognition will happen only when other states recognize it as a state, right? So, constitutive theory, going by the hypothetical situation we just took, would mean that, okay, you have turned 16 years of age, but you will get a mobile phone only when you attain the maturity of 16 years in the eyes of your parents. So your parents are, in that sense, recognizing you of whether you have qualified to be called a 16 years old kid or not, right? So your constitution, the constitution of a state as a state, will come into force only when the recognizing states recognize it to be so, right? So in that sense, recognition is constitutive of state. Second theory, which is declaratory theory, says that state, when it is formed, then it has attained statehood. It is recognized by other states that recognition is merely declaration, but that is not constitution of state. State was constituted at the time it was born. So, for example, a state gets independence on 1st January 2006, and other states, state A and B, recognize it on 1st February 2010 and 1st March 2011 respectively. So, first, as per constitutive theory, for state A, the state which has come into existence on 1st January 2006 is actually constituted for state A on 1st February 2010 and for state B on 1st March 2011. But as per declaratory theory, the thinkers will say that state came into existence on 1st January 2006 only. And the fact that state A recognized it on 1st February 2010 and state B recognized on 1st March 2011 are mere declaration of such state as a state. But state was very much there. They declared it to be state later on, right? And their declaration does not alter the fact that state was there before 1st February 2010 and before 1st March 2011 for state A and B respectively. That means state was very well there, which is factually and obviously correct as well. So, if we now see Article 3 of Montevideo Convention, which says the political existence of the state is independent of recognition by the other states, it actually embodies the declaratory theory on recognition. Right? Political existence of new state independent of recognition by the other recognizing states. Let us now move to kinds of recognition. So there are different ways in which recognizing states may recognize a new state as a state. So first categorization of recognition is de facto and de jure. De facto is in fact. So in fact, a state has come into existence and therefore it is recognized as a state. And de jure is in law. So jure is law. So in law, that is the 4 conditions that we discussed in Article 1 of Montevideo Conventions. All those 4 conditions have been met. So in the eyes of law, in the eyes of international law, the state is a state. State in fact and state in law. Then explicit and implicit. Explicit is where the recognizing states explicitly recognize a new state as a state. This explicit kind of recognition may be some announcement of well wishes to the new state, announcement of maybe congratulations by the head of the state to the new state that has been formed, and likewise. An implicit kind of recognition may be that the recognizing state has not expressed officially a welcome to the new state, but then suppose Olympics is organized in the new state and the recognizing state send its team, or vice versa. So, or Olympics or any kind of games or cultural economic exchange takes place between the recognizing state and the new state without explicitly calling that, okay, congratulations letter or an official note from one head of the state to the other head of the state, but impliedly just starting interacting. So starting of interactions between these 2 states forms implicit kind of recognition. Now, the third category of recognition is individual and collective. So sometimes a recognizing state may individually recognize a new state as a state, while sometimes this also may happen that there is collective recognition, meaning that there are a group of states, 2 or more states, which come collectively and they recognize a new state as a state. So, for example, Latin American countries, they come and recognize a newfound island as a state, or African states, they recognize a new state as a state, or for example, the EU, European Union, recognizes a new state as a new state, as a state. So European Union in this case, or Latin American states, these reflect an association of states, and therefore a recognition by such state would be called as a collective recognition. Another category of recognition is of state and of government. So sometimes recognition is classified as and distinguished as recognition of state or recognition of government. So recognition of state would mean that state X is recognized as a state, and whichever government comes into force, it is recognized because state embodies government. While recognition of government would mean that a recognizing state is recognizing this government and is not recognizing the state per se. Right? So for example, Afghanistan is recognized as a state by most of the states of the world, almost all the states of the world. But when Taliban took over Afghanistan, Taliban's legitimacy of government and the mode of toppling down of the then legitimate government of Afghanistan is a big question in the eyes of international law. So therefore, Taliban may be recognized as a government by some states. It may not be recognized as a government by other states. But once Taliban has come, and for example, there is a trade-related treaty that has to be there between Afghanistan and other state, even if the other state finds that Taliban is illegitimate form of government, still it may want to recognize a state for the purposes of conducting of business or for some other purpose. So recognition in that sense is not necessarily a gift or not necessarily a reward for a new state. It is mostly for political purposes also. So it's not necessarily a recognition of legality or legitimacy of that state, or legality or legitimacy of the government, but it may be purely on practical purposes, business related purposes, contractual purposes, and otherwise. So state recognition are categorized into, broadly speaking, these four kinds. Now let us talk about certain case studies. But before it, because the case studies are varied, we should first see that we should first note that the conditions that we read from Montevideo Convention 1933, the prerequisites, those are important if we talk from the perspective of international law. So legally speaking, those conditions are important, but these are not always sufficient. So as I said earlier also, that there might be a situation where a state says that I fulfill the four conditions mentioned in the Montevideo Convention, but the existing states of the world community may say that we still would not recognize you as a state, depending upon suppose there is an existing state and there is a division that took place, and this division was a rebellious division. A state parted its ways from the existing mother state, and neighboring countries have good relationship with the mother state. Then in that situation, they may not want to recognize a new state as a state. They may find it as an act of animosity towards the mother state, so they may not do it. So that shows us that Montevideo Convention's conditions may be necessary, but then they are not sufficient for a state to be recognized as a state, right? Also, there is one category of case studies in state recognition which is very interesting. This is unilateral declaration of independence. And this is this comes from the example that I just took, where an existing state is there, and a part of it uh, parts its ways from the existing state and unilaterally declares that, okay, this part is now independent. We declare our part independent and no more a part of the existing state. So unilateral declaration of independence is a very intriguing kind of case studies in state recognition, and this is usually considered as a gray area in on the questions of independence, self-determination, and state formation. Why? Because legally speaking, there are certain arguments that, okay, states may declare, a part of state may declare itself to be independent, but then politically speaking, this is a very problematic aspect if we consider the unity and integrity of the existing state. So therefore, unilateral declaration of independence is a very tricky domain of state recognition, which I said that it is known as gray area in state recognition. So still there is no consensus on legitimacy of unilateral declaration of independence. So whether unilateral declaration of independence is legitimate, permissible under law, this still is quite debatable. Three significant examples under unilateral declaration of independence are: first is Kosovo, the unilateral declaration of independence by Kosovo. And there is a very fascinating advisory opinion by the International Court of Justice on unilateral declaration of independence by Kosovo. And I would highly recommend all our students to go to the official website of International Court of Justice and try to find, maybe type advisory opinion on Kosovo or advisory opinion on unilateral declaration of independence by Kosovo. You will be directed to the advisory opinion. Please open it and try to read maybe a summary of it, because it's important, fascinating, and also it would clear out lot of questions about state recognition and what ICJ thought specifically on Kosovo, because it was one of its own kind in this category. Second example is secession of Quebec from Canada in the year 1998, where Quebec unilaterally declared itself to be independent and separate from Canada. Third example is Southern Rhodesia, which declared itself to be independent, and it did so unilaterally in the year 1966. So I would recommend all of you to maybe quickly read something about Kosovo, Quebec, and Southern Rhodesia in terms of state recognition, how these states were recognized as states by the existing states of the world. Then there also is an important point to note here that if parting ways from an already existing state is there, and there's no consent of the existing state, so there's a new state is formed by separating from the existing state, and this now separated state did not take any consent or did not take the parent state on board. So this is known as non-consensual secession. In that case, even today, it is not recognized as a legitimate form of state making in the eyes of international law. Now, parent states, the existing parent states, usually are not very keen on acknowledging the newly formed separate territory which have separated from the parent state as a new state. So therefore, they are usually very slow or reluctant in acknowledging the statehood of a newly formed state. And these newly formed states in non-consensual secession are usually not very peaceful process through which they have been created. They usually are not they are usually born out of separatist movement or rebellious movements. So therefore, parent states are not usually keen, happy to recognize such states as a new state. And therefore, as I just mentioned, that the states which are in friendly relationship with the parent states would also be reluctant in recognizing the new territory out of separatist or rebellious movement as a new state. So even if that state fulfills the four conditions of Montevideo Convention, other states may be reluctant in recognizing it as a state, depending upon friendly relationship or other political considerations with the parent state. So therefore, in the beginning, I said that state recognition is not a legal act, but it is a politico-legal act. That means it is a mix of lot of political and legal questions. It's per se not purely legal act. Now, there's another interesting example about which you all can read, and it is Rosa Island. Now, this was an island. This was first of its kind because it was an artificially constructed island from wooden planks and iron hollow pillars in high seas near the coast of Italy. And this was created by an engineer, and he invited few of his friends to be the citizens of that newly artificially created new state. The state he called as Rosa Island. It's very important because this state also was represented in United Nations. It had its own citizens. It had its own flag. It also tried to develop its own language. So this is important because although this was this lived only a few months or I think 1 year or so, but this is important because it challenged the conventional standards of statehood. Earlier conventional standard of statehood of state having a political territory, a definite territory, or formed out of division of an existing state or newly found state, etc., were there. But then these traditional idea of state were challenged with the formation of Rosa Island, and this was an artificially constructed island as a state. So it declared itself as a state. There also is a Netflix documentary or a movie on Rosa Island. Now, let us see non-recognition. So what is non-recognition? Non-recognition is where a state has come into existence, but other states are not recognizing it as a state. As we discussed, that this might be due to some political inclinations, due to some foreign policy issue, etc. Now, because we discussed about declaratory theory, we know that state has come into existence and it very much is a state. But then other states may not recognize it as a state, sometimes symbolically. So sometimes just as a tool of foreign policy, sometimes for maintaining their friendly relations or maintaining their animosity. They may not recognize a new state as a state, but that does not make that the state is not a state. It very much is a state, but non-recognition may be symbolic, may be political, may be moved due to some other forces, some other conditions may be there, which have because of which the state decides that okay, we will not decide on recognizing this state as a state. Now, international law rules still apply to a non-recognized states. So a state which has not been recognized, that still is a state in the eyes of international law. That means that the rights, duties, and obligations of a state under international law documents, under international law rules or principles that are mentioned in various conventions of the international law, they still would be applicable on a state which has not been recognized, but of course is a state. So, for example, if we talk about prohibition of use of force, which is a very significant principle of international law embodied under Article 2, Clause 4 of the Charter of the United Nations. It says that states shall refrain from using force or threat to use force against each other. So prohibition of use of force or non-use of force is a very significant international law principle. This applies on a state which has not been recognized. That means the state which has not been recognized, for example, a newly separated state. Even if it is not recognized as a new state by other states, still it is under an obligation to refrain from using force against other states. Right? So prohibition on use of force prohibits states to wage war against each other, use military, physical force against each other, etc. So a newly formed state cannot wage war against other states or cannot use military force against other states and call that, okay, because I'm not recognized as a state, so international law does not prohibit me from use of force. No, international law still prohibits use of force for a state which is not recognized as a state. In the eyes of international law, if it has been formed as a state, it is a state in the eyes of international law. Right? So another example, one example of non-recognition is TRNC, which is Turkish Republic of Northern Cyprus. It is a part of Northern Cyprus which is recognized only by Turkey till date. So there's no other state that recognizes this state TRNC as a state, but Turkey. So Turkey is the only state that recognizes Turkish Republic of Northern Cyprus as a state. Right? Another example where a state is recognized by a few handful states but is non-recognized largely by the rest of the states of the world are Abkhazia and South Ossetia. So these are territories, certain political territories in Caucasus, which are recognized as states by Russia, Venezuela, Nicaragua, Nauru, Syria, and some disputed territories in Caucasus. Most of the countries of the world do not recognize Abkhazia and South Ossetia as states, but they recognize these both as part of Georgia and not as separate countries. So, for example, in case of Turkish Republic of Northern Cyprus also, all the states of the world recognize TRNC as part of Cyprus, but Turkey. It's only Turkey which recognizes Turkish Republic of Northern Cyprus as a separate state, but the rest of the world recognizes it as part of Cyprus. Another example that we took in Unilateral Declaration of Independence, Kosovo, the first example, is also an example in non-recognition because it still faces mixed recognition. That is, there are few states of the world that recognize it as a state, but there are few states which do not recognize it as a state. So Kosovo still faces non-recognition by many states of the world. Another example is Taiwan, which is recognized as a separate state by a small number of states, but then there are the remaining states which call it as a part of China. They don't recognize Taiwan as a separate state. So these four, Turkish Republic of Northern Cyprus, Abkhazia and South Ossetia, Kosovo and Taiwan are examples of non-recognized states, the states which are largely non-recognized. Now, what are the consequences of non-recognition? So what happens if a state has not been recognized as a state? First, the validity of the national documents of the people living in such non-recognized states is under a question. National documents such as passport, visa, and other travel documents will be questionable if they travel or they want to travel in some other location, in some foreign location. Then such non-recognized territory cannot have any diplomatic ties or diplomatic representation in the states which do not recognize it as a state. So, for example, X is there, state X is there, and state A, B do not recognize X as a state. In that case, X cannot have diplomatic ties with state A and B. X cannot send its diplomatic agents or diplomatic representation in state A and B, and state A and B will also not like to send their diplomatic agents, their diplomatic representation to state X. But if this state X is recognized by state C, suppose, then state X may have diplomatic relationship with state C, though it does not have diplomatic relationship with state A and B because A and B have not recognized state X as a state. Then another consequence of non-recognition is that the state which has not been recognized by most of the countries of the world, then that state cannot become a member of international organization. So, for example, if Taiwan is not recognized as a state separate from China, it cannot be called a state in the eyes of international law, and therefore it cannot become a member of international organization. So if Taiwan wants to become a member of, suppose, United Nations, then United Nations as an international organization, then Taiwan cannot become a member. Again, if the Turkish Republic of Northern Cyprus, which was also earlier known as KKTC, if that wants to become a member of any international organization, suppose WTO or United Nations, then it cannot become a member of those international organizations. Then these states which are not recognized as states cannot have their own international airlines, but then exception is there, KKTC, which so KKTC was the earlier name for Northern Turkish Republic of Cyprus, that for a short while had its own international airlines, but that was discontinued after a short while. Again, non-recognized states cannot be benefited by international aid. So, for example, if United Nations aid or any other organization's aid or any other foreign aid is to be sent to a non-recognized state, then non-recognized states cannot have that benefit from international aid. But then exception is Palestine, where international aid is provided, United Nations aid and other kinds of aids are given to Palestine, regardless of the fact that Palestine is not recognized as a state by many states of the world. Now, three important questions surrounding this non-recognition debate for the purposes of international law are: first is the question on the capacity of an unrecognized government to sue. So if a state is not recognized, can its government sue other states' government for any wrong that other states have done to the new state, to the unrecognized state? Second question is, how will this non-recognized state assert its immunity from suit by how will the other states assert their immunity from suit by unrecognized government? So if there is an unrecognized state or unrecognized government, and if it tries to sue other state, how will other states say that no, we cannot be sued? And third category of question arises from the legal effect that the acts or legislations of non-recognized state can have. So if the non-recognized states or unrecognized state as indulges in certain acts, so state acts, or it has certain legislations, in that case, how can legal effect be given by other states to such act of an unrecognized state? So this is a summary of the consequences of non-recognition. In our today's lecture, we discussed about meaning of state recognition, prerequisites or conditions for recognizing a state as a state. We discussed about Article 1 of Montevideo Convention. Then we discussed about Article 3 of Montevideo Convention. We then moved to two theories of state recognition, which are constitutive theory and declaratory theory. Then we discussed about kinds of recognition, in which we saw 4 categorizations of state recognition. Then we took into account certain case studies of recognition and other hues under recognition. For example, we discussed on unilateral declaration of independence and other examples. Then we discussed about non-recognition. So what is non-recognition? After non-recognition, we discussed the ramifications or consequences of non-recognition. So I will stop here, and in our next discussion, we will look at certain questions based on state recognition. Thank you so much for today's lecture and your patience.